Morning, everybody. So my name is Emma-Jane Dalley. I'm a partner in the Charities team at BWB, and thank you very much for joining our session today. Today we're going to be talking about charity mergers, which is an area both Paul Voller, who's going to speak later on, and I give a lot of support and advice to our clients on. So hopefully we'll have some useful insights for you. We aim to speak for about 45 minutes, so leave some time for questions at the end. And what I think will probably be quite a jam-packed session. And in that, if we just move over to the first slide, please, Emma, we're going to aim to do a little bit of scene setting and think about whether trustees should be considering merger as an option for their charity, and then look at the process of merger, looking at the initial stages to heads of terms, the due diligence stage, and then the legal merger agreement, and then a bit on getting yourself merger ready, and some top tips. So hopefully that will cover everything that you'd like us to do in this session. I'm going to start off with a poll, if I may, and as Emma has said, your answer is entirely confidential. It just shows as a trend. So is your charity currently involved in merger discussions? So if you could tick yes, no, or don't know, that would be great. Lovely, thank you. So 29% of you are involved in merger discussions currently, 65% not at the moment, and a few of you there who are not yet sure at the moment. That's great. And the next question is moving on to, do you think your charity should be considering a merger? So if you could again pop your answer into the poll box there, that's a yes, a no, or a don't know. So 57% of you there think that you should be. That's a reassuring figure. And no, 34%, and a few of you who are not sure. And final question now, have you been involved in a merger process previously, either at the charity you're currently involved in or in another role? That'd be really helpful to know. Lovely. Okay, about half and half there who have or haven't been involved in the process. So a good mix. So thank you very much for that. And with that in mind, I thought that we would just have a look at a few statistics in the sector at the moment. And the statistics I was going to look at are all taken from the Good Merger Index 2019-2020. And I've put the link on the slide there so that you can access it if you want to look at that in a bit more detail. And this is a survey that's undertaken by a consultancy firm known as Eastside Primetimers, and it covers the period 1st of May 2019 up to 30th of April 2020. But there is an extended section of that report which deals with the initial and very early stages of the impact of the pandemic. Just so some of the headline statistics from that, so up to 30th of April 2020, so the main time area they were looking at, there were 67 mergers between 136 organisations, which was slightly up from the same period 2018 to 2019. And the normal range for mergers in the charity sector in a particular year is between 55 and 75 mergers. And that is, the report's been going from about 2014, so there's about 6 years of statistics to look at. So it was within the normal range for the previous year, and 51% of those charity mergers were within charities in the health and social care sector. As I say, it did also look at the initial impact of the pandemic and looked at the period between May and October last year. And the initial statistics did show that mergers in the sector were beginning to rise, but that has started to even out, and it's now looking more stable and more like that standard year. And the financial footprint of those charities that are merging in that period appeared to be smaller charities, with 92% of them having an income of less than 5 million per annum. And again, within that period, it showed that the majority of those looking at or going through with a merger were within the health and social care sector. However, our view is that the impact of the pandemic is really not yet fully worked through in the sector, least of all in looking at mergers in the sector. Because just like any other strategic project, mergers can take many months to reach a conclusion. So I really do think it's a case of wait and see. And even more so because some of the charities most impacted by the pandemic, so particularly trading charities and those in leisure trusts, arts establishments, theatres, we're not yet seeing the numbers rise there in terms of the number of mergers, and I think that will probably be the case. And it will also be interesting to see what happens when government support, particularly the furlough scheme, comes to an end and the impact that that will have. So moving on to the next slide, please, Emma. The report did show and pulled out some key themes around the barriers to merger and what is stopping charities looking at that. And they showed a lack of knowledge and awareness of the merger process was one of those, and hopefully that's one of the things that we can try and address today. A lack of funding available to support mergers, and finally an absence of immediate motivation to do that. And I would add to that also perhaps a desire on the part of trustees that they don't want to see the end of a charity in a particular era or in a structural form on their watch. And there can definitely be a lack of motivation within trustees to have that happen while they are on the board. And just move on to the next slide. There's an interesting quote from the report, which I just wanted to read out, which is, it is true that merger is not the right option in all cases, and quality matters more than quantity, but we continue to believe that merger should be in every charity chief executive strategic toolbox. This is due to many cases we've seen over the years, where managers who have taken their organisations through it have found clear benefit, be it greater reach and social impact, more holistic services for core beneficiaries, new specialisms and income streams, or enhanced capacity. This is now truer than ever when charities need to take every possible instrument at their disposal as they seek to build back better. And that leads us nicely on to the next stage of our seminar, which is about whether trustees should be considering merger as an option for their charity. And what I think is important to bear in mind here is that trustees should be aware that it's their duty to promote the objects of the charity, or their purposes, effectively for the benefit of their current and future beneficiaries. There is no obligation to keep the charity going in being or to pursue those objects using a particular model. And the Charity Commission's guidance, the essential trustee, what you need to know, which is number CC3, that says acting in the charity's best interests means always doing what the trustees decide will best enable the charity to carry out its purposes, both now and for the future. It's not about serving the charity as an institution in itself or preserving it for its own sake. Sometimes trustees need to consider collaborating or merging with another charity, or even spending all of the charity's resources and bringing it to a close. And equally, the Charity Governance Code, which you'll know was again refreshed at the end of last year, says trustees should consider the benefit and risks of partnership working, merger or dissolution if other organisations are fulfilling similar charitable purposes more effectively, and or if the charity's viability is uncertain. So certainly our view is that yes, trustees should have merger as part of their strategic thinking, and whether their charitable purposes can be better met by collaborating, joining forces, or merging with another charity. Also, I think there's often too much of a focus on looking at merger where you're in financial difficulties. And for many charities, and even those who are in a strong financial position, there are some great opportunities to be had through creating mergers and other collaborations with other charities. But what I would say is it takes a good degree of objectivity, which can often be really difficult to obtain and really does require some strong leadership to get trustees into a place where they consider it and analyse it in depth. And of course, it's absolutely not to say in any way that merger is the right for any particular charity, but our experience shows that charities who have that as a discussion topic regularly are likely to be in a better place to assess whether a merger is in the best interests for them and the right thing for them to investigate, and are more likely to make that decision at a better time for the charity. And where it does prove to be in the best interest of the charity, it means that they are more likely to go ahead with a merger which proceeds successfully. So with all that in mind, moving on to the next slide. Sorry, so it's just come off my screen there. The first stage of any merger project, really for me, is about fact finding. When you are in discussions with a potential merger partner, you're likely to be sharing lots of information with them and discussing things at a high level about what the potential benefits of a merger or any other type of partnership would be. And what I would say is that charities should really bear in mind what information they're sharing, and in particular whether it is confidential. Your information, in the widest possible sense, is an asset of the charity, and like all other assets, should be protected. So it may be appropriate, even at this early stage, to consider thinking of a confidentiality agreement. And we would usually expect to see such an agreement being mutual between the parties, where they both have the same obligations as each other in relation to keeping that information confidential. And for that reason, it is very unusual for it to be contentious, but something that definitely charities should bear in mind. And of course, it's at this stage where you'll be analysing what the key benefits of the merger may be. So just moving on to the next slide, we can have a look at some of those. And by no means are we saying this is all of them. Cost savings, particular back office functions, very often one of the key drivers for merger. Succession issues where trustees are coming to the end of their tenures and struggling to find either appropriate trustees or senior managers to take the charity forward. Investment in joint infrastructure, access to an increased pool of donors, and that ability to bid for larger, particularly government contracts. Again, we want here looking at strength, geographical expansion, gaining new specialisms or functions, diversifying income streams, and of course, just a synergy in the services that your charities are pursuing. And that really is about having an early stage feasibility study about whether the merger is something that is for the benefit of both those charities. Let's move on to the next slide. There are a couple of areas which could probably be said to properly fall into the category of due diligence, which Paul's going to talk about later, but which in my view are helpful to look at this really early feasibility stage. The first of those is about the objects of the two charities, as this really goes to the heart of whether the merger is in fact a feasible one. The trustees of both charities, of course, can only advance their own charitable objectives, and the assets that they hold are restricted for that particular purpose, wherever they may be transferred and whoever may hold them. I'm going to look at legal structures in a moment. The objects of your charity will, of course, be set out in your constitution, and if you're a company, then that'll be in your articles of association. If you're a CIO, that'll be in your constitution, as it's known. If you're a unincorporated charity, it's likely to be in a charity commission scheme or trustees. Now, of course, it's unusual to see two wholly incompatible charities looking to merge. For example, we don't normally get approached by a donkey sanctuary that wants to merge with an old people's home, but the issues can be just a little bit more nuanced than that. And a couple of the areas worth looking at is who are your beneficiaries that your charity supports? Are they restricted in some way, perhaps by reference to a particular geographical location? Or maybe your objects are specifically about advancing a particular object by way of a particular service. So do you assist the elderly, but only by the operation of a nursing or care home, which rules out potentially providing domiciliary care? So it's about looking at those sorts of issues. And where charities merge and their assets are held for more restricted purposes by the merged entity, that can lead to difficulties in truly bringing together the two organisations and running them as one operation. It's not necessarily insurmountable, but should be considered really early in the process. And also bear in mind that objects of the charity are not necessarily set in stone, but in almost all cases would require the Charity Commission's consent before they could be amended. And again, that list needs to be factored into the process and given consideration to at an early stage, and thought about whether any changes are likely to be acceptable to the Commission. And that brings me on to the other issue again that I think is a sort of early feasibility issue, which is looking at regulators and the involvement that they may need to have in the process. For example, the Charity Commission, we've already mentioned, and the majority of you will be registered charities. If the charities involved do have compatible objects and they do have the power to merge, then it's unlikely that you would necessarily need to involve the Charity Commission. But often there are amendments to objects that need to be done, or there are other regulators, including a few that I put on the side there. So the CQC, Care Quality Commission, the Department for Education, for higher education institutions, the Office for Students. And the requirements of those regulators really ought to be factored into the process at an earlier stage to see whether any consents are needed, or whether the merged entity is going to need in place particular registrations and what process needs to be gone through to get that registration in place. So moving on to the next slide. Once those benefits of a merger have been identified, and assuming that the parties are still content to continue discussions, the next stage is generally about putting together what's known as a memorandum of understanding or heads of terms. This is a non-legally binding agreement. I would say the only exception to that is where you haven't entered into confidentiality agreements at that stage, and you may have provisions in there on confidentiality that would be. But its main aim is to flush out the major commercial terms of the deal that the charities have identified and want to progress. And now, I should say this is not an absolutely essential legal stage. However, my advice to clients is normally to go ahead with that, because it is often really helpful. Because, as I say, it flushes out those major issues. And what you will see as we continue to talk about the process of merger, that there is a great deal of investment in the process, both of your time and finances and resources. And if you can't agree some of the key terms at the very, very early stage, then that really should be identified early so that they can either be addressed or the parties can walk away. Now, looking at the issues I would generally expect to see covered in the heads of terms or memorandum of understanding, the first of those is looking at the legal structure for a merger. And there are a number of ways that charities can achieve merger. And if, like me, you like to look at things a bit more diagrammatically, we just move over onto the next slide. This is the first of the options for a charity merger, which I call a transfer of assets and liabilities to the other. So from charity A on the left of your screen, all the assets and liabilities are transferring over to charity B. And this is generally the structure of choice for the majority of charity mergers. And I think over 60% are done in this way. The second option on the next slide is where a new charity is created and the assets and liabilities of both charity A and charity B are transferred into that newly formed charity C. It's generally achieves the same structure as the first one. You've got one charity with all the assets and liabilities of both. However, I would say that this is normally a more expensive option because you have got to establish a new charity and you've got to transfer the assets and liabilities of two into it. So generally it's not the preferred option, but sometimes it is chosen if neither of the merger partners are sort of legally better suited to taking on the merged entity, or potentially there's a desire by neither party to see the other as the stronger party that's legal structure continues. And the third of those structures that I'll mention at this stage is a group structure. That's on the next slide. And this is one where one charity effectively becomes the subsidiary of another. So there you can see charity B has become the subsidiary of charity A. And in the case of companies or CIOs, this is normally achieved by charity A becoming the sole member of charity B and having rights to control it in that way. Now you'll see there's no transfer of assets here, so it is different. And this, I would say, is generally not a preferred option for merger because it retains those two charitable structures. Each will have their own board and competing interests, and it can lead to some interesting governance questions, particularly about conflicts of interest and the ongoing relationship between them about how they continue to operate. However, it can be an appropriate structure where the parties want to keep certain assets or liabilities ring-fenced from the rest of the group. And for that reason, it can sometimes be seen as a sort of first stage in a merger process where one takes control of the other in the sort of what I might describe as a sort of try before you buy scenario. Okay, moving on to the next slide. The other key commercial terms that I would perhaps expect to see in heads of terms or memorandum of understanding are things about how the legal structure will be put into effect. So clearly, if it's going to be a transfer of assets, we expect to see provisions about that. If it's going to be a change of control, then expect to see provisions on that. Some consideration to the really key contracts that are going to need to be in place at an early stage for the new merged entity to work. Other issues, governance issues. What will the board of the newly merged charity look like? Who is going to be the chair of trustees? And what will the name of the newly merged charity be, and what branding is it going to have? Potentially not absolutely deciding that as a final stage, but if one party is going to have its name and branding continue, the other be dropped, then that really is something that should be flushed out at an early stage. And I've seen many mergers fail about disagreements about things around governance, who's going to be the chair, what's the name of the charity going to be, that kind of thing, which is sometimes what would otherwise be really successful mergers. So again, flushing those issues out at an early stage. And again, I'd expect to see something about the timescales, the timeline to achieve the merger, what the parties are looking at there. And finally, I mean, we've talked about it already, but the involvement of regulators, because that would need to be identified at an early stage. So moving on, just one final thing that I wanted to mention at this stage, because it's sort of early consideration. As you probably have gathered, and you'll realise from Paul's discussions of the rest of the process in a moment, is that there is a lot of investment in a merger process and the discussions. And in some circumstances, and I do stress some because it's not always appropriate, a charity or one of the merger partners may be concerned that the other party is looking at other options at the same time, or may be inclined to, and that its therefore investment in the process may become wasted. And of course, there is always the risk that the parties will decide to walk away because they'll decide it's not in the interest of the charity. But where a merger partner is looking at other options, it can become increasingly off-putting. And in those cases, it may be appropriate to put in place what is known as an exclusivity agreement between the parties. And essentially, that's an agreement where the parties agree not to enter into discussions or negotiations with any other party for a period of time while they're in discussions with each other. And it could be one-sided or it could be mutual, but again, will depend very much on the circumstances. That's enough from me. I'm going to hand over to Paul, who's going to talk about the next stages of the project.
Thank you, Emma. Good morning, everybody. So the picture so far is that you've had your early discussions. You might have entered into a confidentiality arrangement. You've probably reached an understanding about how to go forward together, and perhaps have signed heads of terms, perhaps have agreed a period of exclusivity. So on the next slide, how would we proceed to make it happen? What are the next steps? Emma, if you could move us on. So we're going to look next at how to make it happen. And making it happen in this context is really strongly from the legal perspective. There's, of course, an enormous amount that has to be done outside the lawyering. But for the purposes of this exercise and just helping towards a better understanding of the processes, how to get to an end result. These are the things that we'll be looking at in the next few minutes. So we're going to look at due diligence. We're going to look at briefly the notion of agreeing documentation, contract completion, and implementation. We're going to focus more on the processes than the actual content of each phase, because the content will vary hugely, of course, from charity to charity, but there'll be some common elements, and we'll have a look at that. So moving on, thinking about due diligence, what's it for? Fundamentally, it's about assurance and accountability. It's making sure that that the parties are understanding each other well, from a legal point of view, that they're actually going to get the things that they think they will get. The other party owns the property that everybody believes it has, and it doesn't have any horrible liabilities that can't be absorbed and managed. So it's about assurance, and I often think of this in terms of avoiding the black holes and making sure you get the missing stars. So you want to be sure that there aren't any disastrous liabilities that haven't been uncovered and explained. And equally, you want to make sure that the glittering assets that you hope to take advantage of are really there and can be secured. So it's about assurance, and it's about accountability. Assurance for the board, assurance about assets and liabilities, and accountability for the board. It's about enabling the board to be sure that it can explain its actions and come to proper decisions about how to go forward. Should the process be a two-way process or a one-way process? I think if parties are more or less equal and they're putting in together, I think it's very likely to be a two-way process. But it might be a one-way process if it's a situation which is perhaps a bit more in the character of a rescue, where the rescuer will have more questions about the rescuee, so to speak, than the other way around. And before we leave this slide, just a reflection on what's the legal significance of the due diligence process. How do you turn this into legal material at all? Well, the results of all the questioning and answering that will build up in the due diligence process are often translated into warranties and sometimes indemnities. That is to say, contractual promises about the state of affairs of the other partner in the transaction. And the easiest example to point to perhaps is a promise that there is no litigation. So that's a simple idea to capture. And as part of the process of building up the knowledge, there might be a formal exchange of correspondence in the form of a disclosure letter, which would state any exceptions to matters that have been warranted. So to go back to the example of a warranty that there's no litigation, might elicit a response that, that there is some litigation pending, and that would appear in a disclosure letter and form part of the process of establishing liability, and when a matter is disclosed in a disclosure letter properly, not liability. One of the issues that is always exercising is what results should follow if any of the promises turn out to be not true for some reason. And generally speaking, I think it's quite hard to contemplate that these will result in damages claims. And sometimes transactions are more in the nature of a sale and purchase. And we're looking at one at the moment where there is an operating business which is being sold, and so value will pass. And in that kind of situation, you can contemplate that a breach of warranty, a breach of a promise that things are thus and so, can translate into a claim for damages. But where you have trustees who are unincorporated, it's really impossible to contemplate that they would be fixed with any liability, and they simply won't accept it. So whereas in a commercial transaction, I think you would invariably expect warranty claims to translate into financial claims, it's not necessarily the case that you will see that result in the charity context, and that simply becomes another factor to weigh in the process of going ahead. So moving on again, the due diligence process, as EJ has already said, implies a significant investment in time. And one of the key tools in the process is likely to be a questionnaire, and that can be quite an elaborate document. And most firms that are experienced in this kind of work will have model forms of questionnaire. But what you want to achieve in the process is a balanced view of how detailed the inquiry should be, and also a proper focus on the things that are important. So in terms of obtaining assurance in the way that I was talking about earlier, there is a sense in which you will want to trawl over the ground and make sure that the ground is covered systematically. And as I say, there is a place for considering in how much detail you will want to cover all the general ground. And there will be particular areas to focus on. And those are things for discussion with advisors at an early stage. And then in terms of managing the questionnaire going forward, so there will be a formal process of disclosing information against the questions, and you will want to be able to track the information that you give out, and you will want to track the information that comes in response to the questions. Some transactions might go as far as using a virtual data room where documents can be scanned in and made available for inspection electronically, and you can keep track of who's seeing what and that kind of thing. That's really quite a sophisticated approach, but it doesn't have to be like that. It can be physical transmission of papers for review, for inspection, and most of all, I think the last item on the screen there, keep track of what the issues are, understand that what the answers are, and what the consequences are for each element of the transactions that go forward. Then moving on again, who does what? There are lots of people potentially involved in the due diligence exercise. It's going to be led on the financial side by the accountants, and you would probably expect to have a separate financial due diligence report. And the lawyers will deal with a whole range of things that I'll come on to shortly. In terms of who's looking at the stuff within the organisation, there's an important planning step for the merging charities to organise, which is around the role of management and the role of trustees. You might, for example, want to create a small committee of trustees to keep in touch with the transaction as it evolves, and so that not everything has to come back to the whole board at every stage, although clearly all the most important decisions will have to come back to the main board. And also, very important to keep in mind, the effect on the effect of the demands of time and attention in the whole process. It usually becomes very, very intense, very, very demanding, particularly if there are tight timescales. And so there's usually a heavy burden on the finance team, finance director, and his team, or her team. And you will want to be able to factor that in to possible by ensuring that deputies are on hand in order to keep the day-to-day activity of the charity going while the merger discussions and planning and due diligence exercises are being handled. So moving on again, thinking about the legal due diligence, I think it's convenient to see it in broad headings. There's no particular magic about this, but I generally refer to it in these three categories. So corporate, which is really, it doesn't have to be a corporate structure, but it's anything to do with the structure of the other party, their constitution, and if there are subsidiaries and other group arrangements, understanding what they are. So anything to do with the structure of the organisation, trustees, constitutions, the like. The other area is assets and liabilities, contracts, property, people. Where does the money come from? So engagements with other parties, including staff, of course, and we'll look at that again in a bit more detail in a moment. And in the regulatory category, it's really dealing with the authorities, the Charity Commission, the Information Commissioner's Office, and the many and various authorities that organisations are engaged with these days. So moving on again, thinking about planning the due diligence, there's a really important distinction to underline, which is the distinction which EJ has already referred to around transferring assets or transferring control. And I think it's sometimes helpful to think of it in terms of a question of whether you are buying a box with all the contents in it, or whether you are just buying the contents. And in this analogy, the box is the entity that you're contemplating merging with, and the content of the box are the assets and liabilities. And if you're transferring assets, what you're doing is in effect tipping out the box and picking up the assets and liabilities and transferring them individually. And in the transfer of control, which leads to the kind of group structure that EJ was looking at, effectively you hand over the entire box with everything in it. So if we could just move on to the next slide and just think about this a little bit more, because it influences the way the due diligence process happens. So in asset transfers, you will obviously understand that the transferor is the charity itself, and so you'll be concerned about its powers, its ability to transfer rights and obligations. But because you were looking at the individual assets and liabilities, there is an opportunity to pick and choose. I mean, often that isn't actually the case. And people choose to take all the assets and liabilities because that's part of what's agreed to be done. But conceptually, there is the opportunity to take some, not others, and indeed we're working on one at the moment where the organisation will go in three directions. And so some of the assets and liabilities will go to one party and others will go to other parties. 2P is always a major factor in this style of transaction because it's one of the areas where you can't pick and choose. It's a well-known body of law which mandates a transfer of obligations to all the employees. The effect on the balance sheet is important because the assets and liabilities that you acquire come straight into your balance sheet. And there isn't the kind of try before you buy aspect that EJ referred to in the other side of transaction. Documentation is also an issue because because of all the different kinds of assets, they all have to be transferred according to their particular rules. So that can be quite time consuming and documentation intensive. So moving on again, looking at the other style of transaction, although these are rather less common, what we're looking at here is transferring control of the entity. So it's likely to be the members who are effecting the transfer. And as I said before, you're handing over the entire box, lock, stock and barrel. So you get everything that's in the box, like it or not. 2P isn't an issue where you're transferring control because the employees are continuing with the same employer. And the balance sheet effect is quite different because, as EJ's diagram showed, Charity B becomes the subsidiary. And so the assets and liabilities are isolated from Charity A. And that can be quite useful in a rescue type situation where perhaps there isn't time to do detailed due diligence, and you can pursue the transactions kind of try before you buy. And so speed can often be an advantage, or you have the advantage of speed in a controlled transaction that you don't necessarily have otherwise. Then moving on again, thinking about some of the content of the due diligence. I'm not going to dwell too much on this, but just to give you the sort of highlights of the geography of the landscape to be covered. And indeed, EJ has already referred to the importance of understanding powers and objects. And it may be that the members will have an important role. It may be that it's a membership organization, in which case there'll be an issue about how members' rights are transferred and replicated. If it's a controlled transaction, it'll be important to involve the members potentially in the processes of transferring control. And one of the key issues tends to be actually understanding who the members really are. Moving on again, one of the key things to understand is whether there are any restricted funds and the nature of the restrictions. Do they matter? Can they be lifted? They might not matter if, for example, the nature of the restriction is such that the restricted fund can be spent down within the overall plan of how the project is to be pursued. It might be possible to use some of the statutory tools to lift restrictions and enable assets to be applied for different purposes or general purposes. So charity commission intervention might be required, but it might be possible for trustees themselves to exercise the statutory scheme rights to make changes there. Moving on again, land is always a major issue. You will always want to understand what the land position is, whether it's freehold or leasehold. But if you're looking at an assets transaction, then you will be needing to consider the Section 117 restriction on land transfers, and that only applies in the context of an asset transfer. It's not an issue where there is a change of control. Mostly in asset transfers, as EJ has already said, the parties are probably going to have compatible objects, and it may be that the exemptions within Section 117 will be available. Otherwise, you've got to go through the processes of the section, and that just needs to be looked into and understood. If the land is mortgaged or charged, perhaps to support banking arrangements, again, that needs to be investigated and understood. And is the borrowing to be repaid? Is the borrowing to be recreated in another entity, or quite what? Moving on again, personnel and staff is always a major issue. Where you're looking at an asset transfer, because TUPE always applies. And I think everybody knows that the basic concept of TUPE is that staff transfer on their existing terms, and there are important duties to inform and potentially consult. And there is a cost in getting this wrong. So the cost is not measured in terms of compensation in a conventional sense, but there are within the TUPE scheme protective awards, which are potentially financially significant, to which employees are entitled where the TUPE process is not correctly followed. If there are redundancies in prospect, that will be a whole issue on its own, and potentially will have a significant issue on timelines. I put pensions on the screen because you can't really do these kinds of things without talking to, without addressing the subject of pensions. But I won't say anything in detail about that. Next, intellectual property is always a key aspect because potentially there will be trademarks to think about, certainly the branding issues that EJ has touched on. And we sometimes find that there are problems in the field of copyright, or who owns the material that is being exploited by the charity. And again, all these things are within the scope of the due diligence and part of what needs to be explored and tracked down. Moving on again, contracts will be central to the affairs of many charities, contracts with suppliers, whether it's IT or anything else that comes into the charity, and then contracts with customers, whether that's a local authority or any outbound provision of services. And important always to understand that in terms of rights and obligations, generally the position is that you can transfer rights, but you're not free to transfer obligations. And so the position there always needs to be understood, and in particular whether there are any restrictions in those contracts affecting the ability to transfer the contracts. So the non-assignment clauses is what we're concerned with there. And in control transactions, whether there are any clauses in contracts which restrict the change of control. Finally, in terms of the headings for the due diligence exercise, regulatory matters, generally speaking, the Charity Commission doesn't need to be involved in the merger process, but you might want to take advantage of the Charity Commission's enabling powers, perhaps to change objects or release permanent endowment, things like that. Useful also to bear in mind the register of mergers. Important to make sure that the merger is registered, but it may still be important to keep the constituent charities in being for other technical reasons. I'm not going to dwell on the other regulatory parties on the screen, but try and draw things together. And moving on, Emma, so where does all this lead? It leads to a due diligence report, something which surveys the results of all the inquiries that have been made. And depending on how complex the transaction is and time and resources, it may be appropriate to take a staged approach where there's a high-level review of these kinds of issues to make sure there are no absolute showstoppers before getting into a more granular level of inquiry. So a red flags report at an early stage to help trustees decide whether to go or not to go, and thereafter perhaps a more refined view. So moving on once more, the key tips for a good due diligence, I think having a clear vision, what it's all about, where you're trying to get to, make sure as much as possible that people are cooperative and collaborative, because that's what moves the whole thing forward. Being realistic about what's achievable, taking a proportionate view about the importance of any individual issues, and simply dealing with each other in good faith. All these things help to lubricate the process. And finally, then you'll be ready to exchange contracts and move on to making arrangements legally binding. Sometimes it's appropriate to have an initial step of making things legally binding by exchanging contracts with completion to follow. And generally speaking, asset transactions will probably entail more steps because of all the different kinds of assets to be dealt with than controlled transactions. And then on completion, in an assets transaction, all the different assets will be transferred according to their particular legal characteristics. In a control transaction, control of the box will pass. How do you make yourself merger ready? I think the best tip is really to try and do a self due diligence, and from there you can identify the risks and try and get yourself in good shape to be a good merger partner. And then finally, just drawing all the comments from the 2 sessions together, I think the most important thing is to think strategically, be open to the idea of a merger, because I hope this session will have shown you that it's doable. The barriers are barriers that can be overcome, and it is about the object, it's not about the institution. Don't underestimate the difficulties of making a good cultural match, and make sure you get good advice and plan carefully. Thank you very much, everyone.
Thank you very much, Paul. I'm going to move to the questions. We've had quite a few questions in, so we'll do our best to go through all of those. Just start at the top. Someone has asked why they think there's so few mergers in the charity sector compared with the commercial sector. Again, I think that really goes back to some of those barriers to merger around lack of awareness, charity trustees particularly not wanting to end the charity in its current form while on their watch. So I think it's all about going back to those barriers that we talked about at the beginning. The next question, my charity has experience of receiving a legacy. One of the other beneficiary charities has been re-registered as a CIO, but not entered the transfer on the mergers register. Strictly the legacy failed. Should such a charity have registered the event as a merger to protect legacies? Is there risks of doing so, such as assuming liabilities too? I mean, this will really go to the way and the manner in which that charity re-registered itself. I suspect it was unincorporated and wanted a limited liability structure, so it moved to that. And I suspect it took on all the assets and liabilities of the unincorporated charity. Should it have registered on the register of mergers? Probably, depending on, almost certainly, depending on how that was affected, and that may have saved that particular legacy. But there are limitations to the register of mergers that we ought to be aware of, but certainly it looks like.
I think on that point, EJ, I think it's worth just contemplating the idea of keeping the merging party in being. So if all the assets and liabilities have been transferred out in the transaction, you might still want to keep the charity in being in order to receive legacies. We've got an example like that in the office where the merger completed 3 years ago, and the charity is still receiving legacies. And although you can put it on the merger register, as you say, it's just easier sometimes to have the legacies drop into the old charity and pass them on.
Sure, and I think it's a balancing exercise there between the risks of the register of mergers and the sort of burden of keeping that shell charity going. The next question was, is there a place that I can look to find charities that are looking for a merger partner? There are consultancies that exist out there who are interested in putting together potential mergers. Again, I would say also it's about looking at the charity that perhaps in your area or in your particular field, and just having some off-the-record conversations about whether that's something that they would be happy to think about. And often key to that is thinking about whether that approach should be made at executive level or at trustee level. And that can really often depend on the charity and how you operate, really. I don't know if you've had anything to add to that, Paul?
No, I think that's right. I think it is hard actually to find merger partners. So talking through associations or groups where you've got like-minded charities, and as you say, there are organisations out there, but I think it is hard. Yeah.
Yeah, I'd agree. I would say be bold and have those conversations and try and open those doors if you think that's the right thing for your charity. The next question is, if you transfer assets to charity B, do you have to transfer liabilities? So the sort of roundabout answer to this is probably yes. If you are merging two charities together and you are taking all of its assets, you can't simply leave its liabilities behind, because you would make it immediately insolvent, because it would have no assets to meet those liabilities, and therefore it wouldn't be a transaction it could enter into. So normally, for charity mergers where you are looking at taking everything out of one charity, you would be looking at taking on the assets and liabilities. And that's another reason why the due diligence process is so important, so you can understand not only the assets, the on the plus side, but also the liabilities you may also.
Yeah, in one that we dealt with a couple of years ago, there were real concerns about liabilities that might come out of some safeguarding issues that were in the history of the charity. So those liabilities specifically were left behind, and the charity was left in being, and they took out an insurance policy so that there would be an asset against which any claim might be made. So that was an interesting example of carving out one particular kind of liability, but otherwise, as you say, EJ, it doesn't commercially make sense to transfer the assets without the liabilities.
Right, the next question here. Would it be more typical of charities to merge where they had similar objects, or are there instances where two charities with quite different objects may consider merging to complement each other's proposition, perhaps more like a commercial acquisition to acquire expertise, reach, services? Certainly more often you will see charities with compatible objects, but where they're not compatible, you're probably looking more at potentially one of those group structures where you sort of combine in the group, and what a typical example of that is where you have charities that are designed with particular different geographical areas in mind. So you'd have a group which has, perhaps the southeast, southwest, and the north in different charitable vehicles. If they are just looking at complementing services, again, it might be just more collaborative working that you're looking at there. But it really depends on what it is you're trying to achieve by way of doing the merger as to the best structure that would work for you in that scenario.
But the idea of combining charities with different objects is quite. I mean, it's in the notion of charity law quite deeply. The idea of combining assets to make them to enable them to be more effectively used together. So you shouldn't be reluctant to consider the idea of combining charities with apparently different objects, although overwhelmingly I think it's charities with compatible objects that merge.
I'm just conscious of time. We have also obviously gone over the hour, but I'm happy just to answer a few more questions if people want to hang on, and if that's okay. One question here: if a charity gifts its real estate property to another charity with identical purposes, is the only transaction really a property transfer via lawyers and updates at the land registry? Again, it would really depend on the individual circumstances of your charity, but it does sound like a relatively straightforward process there of gifting property as opposed to a technically a sort of merger and the moving of other assets as well. Another question here: once a charity has gifted all its property, cash and closed its bank accounts, does it automatically become dormant? If registered with a charity commission, should it deregister? And that goes back a bit to the issue we're talking about the register of mergers, and whether you would want to keep that charity on the register as a sort of effectively a shell charity in case any legacies come in. But once all the assets and liabilities have gone across, it would effectively become dormant. If it's a company, it would probably be filing dormant accounts at that stage. Right, just quickly moving on. If a charity has a profitable trading subsidiary, how is this best dealt with, particularly if it doesn't fit strategically with the new merged charity? Lots of options there. You could look at potentially trying to sell that subsidiary to another entity, or you could be looking at a merger with numerous merger partners involved. But if it's something that's very not related specifically to the charity. It may have some commercial value that could be sold off, which would be an interesting thing to look at. Can you envisage a scenario in which a hostile takeover occurs as opposed to a mutually agreed merger between charities? That's an interesting one. I think we've probably all seen in our time charities turn a bit hostile over time. I really think this depends on the financial situation in which one of the charities finds itself in. Paul, I don't know whether you've got anything to add to that one.
Yeah, it's difficult because the hostile takeover notion, I mean, it inhabits the commercial world, and it's driven there by the ability of members, shareholders, to dictate outcomes in a way which is generally not feasible for charities. I mean, conceptually, you could imagine a charity writing to the members of another charity that it wanted to take over, and write to those members saying, here is a better future, vote in favour of the transaction set out in the appendix. The nearest I can think of it in actual practice that I've come across was a case where it sort of went hostile halfway through, so all the parties were engaged, and the board of trustees split very badly, and the members had to intervene to resolve which direction the transaction was going to go.
I suppose that situation where members are different from individual trustees. Right?
Yeah, absolutely. Yeah,
they are the same people. A question here about what is Section 117. So that is a section of the Charities Act which relates to how property of a charity can be used and places restrictions on particularly on selling it. Normally it can allow a charity to transfer property by way of a gift to a charity with similar objects, but certainly if you're selling it into the commercial sector, there are a number of hoops you need to jump through, including getting a surveyor's report and selling in accordance with that to get best value. It's all about ensuring that a charity gets the best value for its assets. Conscious that we are a lot of people having to leave, but if Charity A proposes to take over control of Charity B, but Charity C has the right to appoint all trustees to Charity B, to what extent does Charity C have to be consulted or approval sought? And can Charity C influence the process in Charity C's interests? That one is really going to depend on the precise nature of the constitution of Charity B, and in particular who its members are, who have the right to control its constitution. So that would be the place to be looking for that one.